is nothing but there is an existing field of knowledge, and there's some ambiguity in certain areas, and you're just going to fill up the blanks. You are going to fill up the blanks or the gaps in it. So that is a major definition of it, and thereby you're contributing something new to the existing field of knowledge, right? So you're going to be an innovator at the first sense. Now let's look into the nuances of legal research. Now, finding law on a particular point or a question is not so easy as it is presumed to be. It involves a systemic search of what? Of legal material. It might be statutory, it might be judicial decisions, it might be supplementary, like legislative debates which take place. Those are supplementary which you can add to. So all these can make up your findings with regard to what a point is or what a law is on a particular issue before you. So for making the development in the discipline of law, one needs to go into the underlying principles or reasons of the law. Now, friends, you might have gone through the important decision in Indian young lawyers' decision, wherein the Supreme Court happened to talk about constitutional morality, right? And all of us being constitutional law students haven't ever dreamt of what is constitutional morality while we were studying constitutional law, right? So these were taken up or picked up from the values or ideals which were latent in the constitutional, the body of the constitution. Understood? So you find that every law is a product of social experience, and it is based on certain value precepts. And you are going to investigate as to the value precepts which underlie this particular legal provision or the law aspect. And so when you do a legal research, it is primarily not only the law which is you are going to look into, also the value precepts which you are going to investigate, and what sort of changes have come about with regard to the value precepts. Do we need to accept you might visualize the situation wherein we were not prepared to accept the transgenders as a gender as such. Now we have come to the position that they are the third gender, right? So this is a development which has taken place in our mindset as such, and this has occurred just because of the reason that the ideals which were underlying under the constitution were due to judicial creativity was being put before us. Understood, and that brought about a pragmatic change in the process or the status of considering a fellow being as such. So what I'm going to say is that, what I intend to say is that an approach becomes systematic when a researcher follows a systematic method. Now, friends, we need to look into the question of how legal research is different from other disciplines, as research in other types of research. The journey of law has its roots in legal research, since law is dynamic, as all of you know, and needs to be modulated based on the requirements of human life. Legal research forms an integral part in the life of law professionals, whether they are law students, lawyers, academicians, practitioners who are interested in legal knowledge. Hence, vast knowledge is essential for a researcher in law compared to research in other disciplines. Legal research has a direct impact in society. Human relations, unlike other areas of academic research, the research in law has always an interdisciplinary character. So you take any subject of your research into, it necessarily has a dimension or an impact on other disciplines. So always you find that legal research is of an interdisciplinary character. Now, friends, look at this particular. Not that. Look at this particular chart, where I'm going to say about the relationship between society, science and technology, and law. I would like some of you to say that what is the impact has science made on as individuals? Major impact of our contemporary time. Anybody? You have your gadgets, right? Whenever your teachers come before you, you Google up and you ask them questions. At times, you also Google up, not interested in listening to the lecture of your class. Do you do that? Okay. So you find that you want to find things immediately and you Google up and you look into things. So it has immediate effect on our lives as individuals. It does have. Even at midnight, you Google up certain things, right? You watch movies, you read. Now you no longer want to read newspapers. You want to only read the Google News, right? So you find that our individual life has been greatly influenced by science and innovation. But at the same time, you find that we are also, law as a discipline is also controlling. As a result, you find that a lot of laws are coming which are controlling science as well. So there's a twofold relationship between science on one hand and law on the other hand. Anybody can tell me what is the twofold relationship? On one hand, you find that law is controlling science and technology. Any example of it? You have the IP regime, right? You have the patents, you have the copyright, you are controlling the science development of science on one hand. And on the other hand, you find that you are using science for legal research. And that is where you find that technology and innovations do have a great impact on our life. There is a symbiotic relationship between law and human activities that by using the services of science, create new resources, tools, devices, equipment with the goal of improving the living conditions of man himself. The meaning of the relationship between science and law is twofold, which I've already said. That is, on one side, you find that law is controlling science, and the other side, law is also using science. So the various ways in which law employs technology is in court practice, drafting of pleadings, e-filing, virtual hearings, etc. And we also conduct teaching online classes, which we have done it during our COVID times, and at times we do it now also. We conduct MOOC courses as well, and we also utilize it for academic legal research. So the next slide, please. Now, before going on to that, I would ask you what are the benefits which you get out of technology by use for legal research? It can be for academic research or it can be for any other research which you do. What are the benefits of it? Why do you use your gadget or laptop or internet? Why do you use it? Yes, exactly. And it is more accurate. You can trust it, right? So you find that automated process brings in clarity, accuracy, as well as it is quick and efficient. It brings in an ease of research. If you are going to search in a book, it will take a long time for you to search and gather information. But information is at your fingertips when you're using a gadget. And it cuts down the risk of errors. It promotes collaborative research. That's the one important part of it. Collaborative research. Now, if you want to interrelate law with biology, you can do that. You can find out niche areas of interface between law and science. Take, for example, you are talking about sensor technology. Okay. And you're talking about what are the laws with regard to sensor technology. And you will be talking about the right to privacy, right? You'll be talking about right to autonomy. You will be talking about all the existing laws which can be gathered, and you present a paper on that or a thesis on that. Okay, fine. So it promotes collaborative research. It ensures transparency in research. So right now you have all the plagiarism software. Do you do plagiarism check for your assignment? Yes. So you are supposed to paraphrase it, right? All your thing, teachers will insist that paraphrase and read it out. And what you do for that? You go against the support of the internet. You have sites which do the paraphrasing for us, check the grammar for you, and then I find somebody giggling. So I think that they are using all these techniques. Fine. Okay. It ensures transparency in research. It increases access and affordability. So before that, you had to take a book. You have to go to the photostat shop, get it photostat, nothing like that. You get a scanner, you do that in your mobile, and you, or an ebook is available, you do the research. Okay, so it's very efficient. The time consuming process for research has been very minimized, and you find that, and it has also reduced human error, unlike the earlier. I happen to listen to a reference to some of the lectures that was taking place earlier here today. So one of the professor was talking about doctrinal research, various kinds of research, and where you have the qualitative and quantitative analysis coming in. Often you find that in these research at the traditional system, there were chances for errors to come in. But of late, with the use of the digital technology, you find that the rate of errors coming in has been substantially reduced. So I am talking about the flowery part of the use of digital technology. Now I'll specifically speak about some of the beneficial part, then we'll go into the nuances of it, okay? It has increased the speed of access. By this I mean that a click of the mouse takes one to the text of a case cited by the author of a book or an article or even a judgment. Another click reveals the status of the case as a precedent. An issue typed in a verbatim from the draft of a brief retrieves 20 or more cases directly on a point. This is very useful. Now, if a client comes, approaches you, and you are being given a particular issue, and what you do is that you draft it out, and then you are trying to, you are going to identify the particular case in connection with the brief in hand. It's being done within a couple of minutes. So you can use it in a very, very quick way. Rather than searching your AR and all that, SEC, you are going to do it very directly. So your time is being saved. The second aspect of it is the ability to acquire information previously inaccessible. Now, by using Westlaw, Lexis, or similar database, an attorney due to appear before a panel of judges in a case, an employment, for example, an employment discrimination case, can discover how each of these judges had ruled in previous employment discrimination cases. So now you can look into the psyche of the particular judge who's going to decide your cases, exactly with regard to the number of cases decided by that particular judge in a particular subject matter. So what is the pattern of that decision-making process which has been undertaken by him? And then you can come to the conclusion of how is he going to decide your particular case and what would be your defense. So you are being empowered to draft your pleadings in such a way that you get a better hand over it. So you are looking into the psyche of the particular judge who is going to decide the case. Okay. And as far as an academic research is concerned, running a subject research on a computer will retrieve unpublished as well as published cases. These unpublished cases were completely inaccessible in the past when they were undisseminated and unindexed. Now you find that again, the researcher gets the edge over the research he's taking. Unpublished records are available inside where you can pay a subscription fee and you can get the data. Now, I would equate the legal research with the jigsaw puzzle, but with some added complications. You don't know the picture the completed puzzle is supposed to form. You don't know how many pieces the puzzle has. And you have to assemble the puzzle under the extreme time pressure. That's there for all of us, right? This analogy captures two great challenges faced by those performing legal research today. They don't have enough time for the task. They lack the confidence in the results. It is at this juncture, we are not confident as to how are we going to solve the problem which is at hand. So it is at this point you find that the importance of the technology comes in. So that we need to look into what are the traditional modes or what is the method of doing legal research. You might have listened to other aspects of it. I will be just looking into that technical aspect of it and the distinction between traditional research and the modern form of legal research. Traditional method, of course, you were looking into the manuals. The researcher uses books, journals, digests, manuals, etc. It consumes time and need not be accurate and precise. So your what to say, your final findings need not always be correct as such. Now we are looking into the concept of computer-assisted legal research. Now, computer-assisted legal research is the technology that allows lawyers, judges, academicians, and students to bypass the traditional law library and locate statutes, court cases, and other legal references in minutes using a personal computer, research software, or the internet and an online connection. This form of research involves the use of information resources, including e-books, e-journals, full-text databases, bibliographic databases, CD-ROM databases, and other e-learning resources. Since the mid-1990s, the Internet World Wide Web has provided the necessary technical platforms to enable free access to computerized legal information. Prior to the web, there were many online legal information systems and numerous legal information products distributed on CD-ROM, but there was no significant provision of free access to legal information anywhere in the world. Now I'm going to talk about jurymetrics. Okay. The term jurymetrics was coined by Mr. Lee Lowinger some years ago as a convenient way of using scientific methodology in legal inquiry. If you talk about Mr. Lee, you find that he was the first person who said that you can use the way back in 1949, he said that you can use statistics and probability and also computers by 1949, remember the year. He said that for in the field of legal research. So he coined the terminology jurymetrics, which he says that it can be the contemporary technology can be used and in the way of doing legal research. And this terminology jurymetrics is also called as cybernetics. Okay. Now I would be talking about the 5 phases of using computers in your legal research. This is both quantitative as well as qualitative research. Now the first stage is conceptual stage. Okay. In the conceptual phase, you find that this is a stage where your formulation of problem comes in, your review of literature, theoretical framework, and formulation of hypothesis takes place. In this phase, computers help in searching for the theme. Now you will be at loss when your guide says, so you go search the particular theme on which you are going to do your research. And there you find that the computer can be a source of great support. So you get along with a lot of legal issues which are unanswered and which needs an answer. So you find that it helps in the search for themes, it helps in the search for literature and bibliographic references stored in the electronic database in the World Wide Web. Thus, it can be used for storing relevant published articles to be retrieved wherever needed and whenever needed. Now, the next stage is the role of computers in designing and planning phase. Designing and planning phase consists of research design, population research variables, sampling, plan, reviewing research, and pilot studies. What are pilot studies? Pilot studies, friends? Oh, no. You need to have a pilot study before doing a full-fledged study. Pilot study is nothing but the sample population is really less. You take a 15 number and you do that, and then you find that this study is going to work, and then you do it in a larger scale. That's it. Okay. Several softwares are available to calculate the sample size for a proposed study. Have you heard about NCSs, PASs, and GESs? It's such a software that you can use it irrespective of the number of the population, the number of samples, the extent of your sample. Okay, you can use it. And then the standard deviation of the data from the pilot study is required for the sample size calculation. Now, the role of computers in the empirical phase. Now, empirical phase consists of what? It's the collecting of data and preparing for the data analysis. Now, the data storage, the data obtained from the subjects are stored, and you know that you do that. Often you do that. You do that in your Word file or in your Excel sheet. Why do you do it in your Excel sheet? Friends, why do you do it in your Excel sheet? You also do it in your Google spreadsheet, right? Why do you do that? You feel sleepy, friends? It's easier to maintain data as well as you can correct it also. You can modify it. So your research becomes more easier. Suppose you find that it is not correlating, you are just making a change. Understood? So it's more easier when you do it under your spreadsheet. And thus it helps in data entry, data editing, data management, and the consequent follow action. It follows a greater flexibility in recording the data as well as in analysis. Are you able to follow me? Yes. Okay. The fourth stage is the role of computer in data analysis. This is very important stage, friends. This phase involves statistical analysis of the data and interpretation of results, which often law students are not. They are not good at math, nor are they. Some of them are. I need to concede that I am not good at math. Okay. So statistics, you say, no, I am comfortable with my doctrinal research. Don't ask me to do empirical research. Fine. Most of us do that. But friends, of late you find that the study of law should primarily focus on empirical analysis for us to be real changers in policy making. So because we are much needed, though we consider ourselves to be worthless, we are much needed by the policy makers. So if you want to do a policy analysis, any research question on what is the rate of parole being granted by the state government to the criminals or the prisoners, and you are making an analysis of that, then you have to necessarily go in for a field study, right? You are maintaining a spreadsheet, you're doing all that. But then the statistical part needs to be taken care of. And there you have digital tools to help you. Don't think that it is frightening and only a statistician will be able to help you out. You can do it provided you know the tools which are being applied. Okay. And for the analysis, software like SPSS, NCSS, or PASS, STATA, and SYSAT. I'm not just spelling it out because I don't know the full name of it. But these are the most widely used software, okay, which is being used for empirical analysis. Now, our university, every 6 months, we do a course on SPSS. So SPSS is available, the training program is available in most of the universities. The rest of the things, you can have online classes as well, where this is being provided to you. And I think that you have statistical teachers here, right? You have. So your university will also be providing you the assistance for it. They can be like calculating the sample size of the proposed study, hypothesis testing, and calculating the power of the study. Familiarity with one particular package is sufficient to carry out the most intricate statistical analysis. That is the reason why you say that if you are aware of SPSS, please don't bother about other things, because one particular tool by itself is sufficient for you to do the statistical analysis. The fifth stage is the role of computers in research dissemination. This is the publication stage, wherein the research work is typed in PDF format or Word and published in the net. Now, what is legal innovation? The legal arena, be it the legal profession, education, or legal research, is written by innovation, even if it lacks a common definition as to how it applies to legal delivery, education, or research. Innovation is an overused, exaggerated term when applied by law. The clash between legal fundamentalists and the legal industry is very visible. What is this legal fundamentalists and legal industry. When you are asked to do that which you are not flexible with, or when you are not comfortable with, what do? You say that it's hard for me. I don't need to do it. It's not good. We can go to the library and we can do the research instead of doing this analysis and all that using digital technology. I am comfortable with my whatever I have learned it. So this is where you find that there is a constant struggle between the fundamentalists, the legal and the legal industry. By the terminology legal industry, I mean to say that there are companies which are offering you legal solutions online. This is the legal industry where you have if you go up with a problem, they do the research part for you and they give you the final analysis. Often, the 2 days back, I got a WhatsApp, message saying that, are you interested in doing a PPT presentation? If so, please contact so and so. And they contact with you. We do we craft the PPTs in such a way that your audience listens to you and watches the PPT so well that you can be very happy with. Probably I didn't go for it, and that is why my audience is so crimping. Okay. Okay. So you find that is the reason I said that the legal industry is advancing in such a way that the legal services, including research, is being provided. And so you need to be equipped as to what is the software which is available, what are the databases which you can use for, and what can the digital statistical tools which you can apply. So a principal force of resistance to legal change is fundamentalism. So friends, have you heard about gamification in legal education? Gamification in legal education. You use games. Teachers use games. They give a problem to the student and they ask the student, they give them the gadget. And what they do is that the student analyzes the problem, comes up with a legal point, and then the game is played. The students are being categorized into two, and then the game starts. And those who are able to solve the game within a couple of, based on certain time frames, they will win the game. And by virtue of it, the student comes to know what is the legal position, what is the law on that particular subject matter, what are the decisions, so that he wins the game. Understood? So this is the process of gamification. I think some of the national universities have already incorporated gamifications in their legal education, legal law schools. Okay? So you find that there is a resistance or not only among the students, but among the faculty as well, as to you go to the library, you do your research. And only then you will get an exact answer for it. So that resistance is being termed by certain jurists as legal fundamentalism. And they say that this is your mindset not to change with the situation. You don't want to change because the situation, you don't want to accept that the reality that there is a science and there is a technological revolution and you need to accept it. Hence, leverage the technology is the need of the heart, and that is meant by legal innovation. So the clash between the fundamentalists, legal fundamentalists, and the industry. And the industry saying that if you want to give a service, you need to be updated with the technology. And that is basically meant as legal innovation. Now, friends, I will just give you a gist of what are the digital tools which is available for legal research in India, which all of you might be knowing. That is SEC Online, which is a product of the Eastern Book Company, which provides Supreme Court of India cases published in SEC Weekly. Manupatra, which all of you know, It's a comprehensive online legal and business policy debate. It contains judgments of the Supreme Court, High Court, etc. Taxman Online. Do you have Taxman Online here? It's for tax matters. Okay. Taxman Online. It's a subject-based database and it provides case laws on direct taxes, indirect taxes, as well as company laws. It extends its coverage. It covers acts, rules, regulations, and circulars regarding tax laws and company laws. CLA Online, which is India's premier online exclusive e-library on corporate or SEBI and business law since 1950. For the House of Corporate Law Advisors, it's one of the oldest online platforms, as well as AR Online, Law Street India, taxsutra.com, which is again a tax-based online. Then IndLaw, which is a business-to-business internet provider of research modules relating to Indian legal, tax, business, and regulatory issues. How many of you are you have commercial law here as specialization? So, criminal law journal software contains data of various high courts and Supreme Court decisions, as well as foreign courts from 1960 onwards. Now, you have Corporate Law Advisor Plus, which is a database, which is a product of Corporate Law Advisor Limited. It provides digital contents of Corporate Law Advisor, Corporate Magazine, along with business law supplements. Free Law, which is one of the best online platform which is available. India Kanun, which everyone knows is free. 5C IP, so it's for IPR related research. InflipNet, which is available. InflipNet is available here. It's free. InflipNet is available everywhere in all the universities. So it's a project entitled National Library and Information Services Infrastructure for Scholarly Content, being jointly executed by Ishod Sindhu Consortium. InflipNet Center and the Indus AICTE Consortium, IIT Delhi, provides cross-subscription to e-resources subscribed by two consortia. Subscription to Indus AICTE resources for university and Ishod Sindhu resources for technical institutions. Access to selected e-resources to colleges. So, then apart from this, you have blogs and sites. Is it not? Please don't refer to blogs while you quote in a legal research dissertation or paper. Blogs are never considered to be an authentic resource, but you might take ideas from there and do further research on it, but never quote it in your dissertation or thesis. Okay, so IPleaders, Bar and Bench, Legally India, Law Times Journal, etc. So what are the international online legal research database? Westlaw International, right? Westlaw International, Westlaw Asia India, and International. The primary legal materials are available in jurisdictions of UK, USA, and Commonwealth countries. Okay. So in addition, it provides proprietary database services. Information resources on Westlaw Asia include more than 40,000 databases. 40,000 databases with case law, state and federal statutes. Okay. And administrative codes, newspapers and magazines, public records, law journals, law reviews, treaties of India, Australia, Canada, UK, US, and EU. Okay. And then it is IP-based database, so you need to pay a hefty amount. Do you have Westlaw here? Westlaw Asia collection includes 1,600 database plus academic journals, legislations of Australia, Canada, European Union, UK, and USA. Hain Online. Again, it's a subscription based, right? You have. Okay, then you people are lucky than us. We don't have. Okay. It's an online research database with more than 100 million pages of legal history available in the online, fully searchable, image-based format. So why is it said as image-based format? Now you have talk, here, Plato's work. What is Plato's work? Republic. The original version of it is there available in this particular Hain Online. Every original text of it is being available. So what you need to do is that you just need to quote it in your as an original. It's a primary source. Understood? It can be treated as a primary source. So Hain Online bridges the gap in legal history by providing comprehensive coverage from inception of more than 2,000 law and law-related periodicals and 5,000 plus classic ebooks. So Hain Online, one of the important aspects of it is provides the exact page images of the documents in PDF format, just as they appear in the original print. Next. Do you have that? Okay, I will not talk much about this. Should I? You know what Hasbury laws of India is? Anybody knows what Hasbury laws of India is? Do you have Hasbury laws of England? What is it talking about? You haven't opened it or what? It talks about how the common law. You might have the awareness of how the common law thoughts develop, how the crimes develop. You know, and these are collection of lectures which give you insights on that. Okay, so you know about the common law tradition as such when you read it, and you find that this has necessary impact on India as well. So all these collections are available in Hasbury Laws of India. Okay. So tomorrow you'll go and not Monday you'll go and read. Okay, thank you so much. Okay. So then you have the JSTOR. Okay, JSTOR. It's a free site. All of us do. It's not a not-for-profit service that has scholars, researchers, and students discover, use, and build upon a wide range of content in a trusted digital archive. We use information technology and tools to increase productivity and facilitate new forms of scholarship. Now, eHeart. I am not going to talk much about JSTOR because most of us know what JSTOR is. Okay, eHeart. eHeart Book Publishing is an online database providing books published by eHeart Books. Publishers, library may choose selected book titles through one-time subscription fee. So if you want an ebook, you can pay a one-time subscription fee and you can take and you can read it. Being an IP-based database, students, faculty members, and research scholars may browse the full book within intranet. Library may add further titles by adding additional subscriptions. So if your library wants eHeart, a book from eHeart, what they need to do is that they can pay a subscription, get the book for a time frame, ask the students to read it, and then the students use it. After that, we can it is being returned. If you want a renewal of it, it can be done. Now, the final part of my presentation. Now, after the Google and internet has come in, what is the next result? Something which is not anticipated from me by the organizers, but I need to say the limitations of this technology. I am not a legal fundamentalist, but I would say that the course of our research has taken a drastic change in the sense that we are not prepared to think. We have lost somewhere we have lost our creativity. We find that the analysis has come down very less. Modern generation, they just want to Google, they don't want to think and ask questions. So the research inquisitiveness, the last part of my presentation, the last point which I've said, and specify on that particular point. Every person has an instinct to question something, but then a researcher especially a student has to question everything. Advocate necessarily has to think that what is opponent advocate would think of and what would be in his pleading, and then to become prepared with those to answer the same, to put forth a effective defense. But what is happening today is that just googling up, making your pleading, filing it, e-filing, e-hearing, and nothing concrete happens. Is it not? This is not for friends. This is not only for the students or the researcher or the faculty as such. I would say the entire judiciary has because of the impact of ICT. Okay. And then you find that often there's a security and cyber attacks on our systems. And most of the time I have found my research scholars coming in crying and saying that, ma'am, I lost everything that what I have written, I've stored in my system. So there are chances for cyber attacks. So there is a chance of data security as well. Then you find that computer assisted learning solutions may be difficult to purchase. Of course, people like me find it very difficult to purchase it's costly. So everybody can't afford to purchase it and implement because of the cost barrier associated with it. Software can become outdated. That's also one major problem. And the risk of over dependence on technology. And as I wrap up a presentation here today, you find that use of technology and innovation is inevitable in contemporary times. So we can't say that, no, I'm not going to use because my research skills will not be, I will get hunted and it will not grow if I'm using digital technology, then will be outdated, it is over. So you can't say that I don't want to use my gadgets for research. Quality research is indispensable when it comes to practicing law, and internet has burgeoned into the primary source of information. A task that used to take the arduous perusal of manuals, journals, and books now takes seconds. Information is being uploaded and updated within seconds, paying ways for swift legal research. A vast legal online depository of legal data has been created with numerous blogs, websites, and forums dedicated solely to legal knowledge. Technology has made information accessible. Therefore, the only thing left now is to make best use of that technology and to get rid of the traditional approach. And the stepping stone for it is for an open mind, for the law school to take active steps to disseminate knowledge to law students and the benefits of technology in legal research. Any questions? Please. Any questions? You don't want to ask me questions? So this is an ethical dilemma which is being posed by technology. You want technology on one side, you want the research to be done, but then you say that you don't use technology. You know, if you ask a school student also, he or she is facing the same dilemma. The teacher sends a note through the WhatsApp. Her mama says, no, don't use the WhatsApp. So this is so with regard to a legal researcher. So the timely use of the technology is one of the what we need to keep in our mind. You need to use gadgets, but in a balanced way. We need to use the technology, but in a balanced way. That's the only advice which I can offer to learned people like you. Thank you for your patience.